Welcome everybody, and thank you for joining this Altamimi webinar on the new security over movables asset law in Qatar. For those of you who don't know us, on my right is Roy, who's a partner in the litigation team, and on my left, Mohammed, who's a senior associate in the banking team. I am Matthew, and I'm in the banking team in Qatar. We are going to speak to you today about the new law that's been published in Qatar over movables security. We're going to keep the session exactly to an hour. So if you have any questions as we proceed, if you could ask them via the chat or Q&A function as part of Zoom, and we'll answer those towards the end of the session. If you have any further questions at the end or we don't respond to them, we will follow up, or you can reach out to us individually. We'll provide our contact details at the end of this. Next slide. So we are going to be talking about the movable asset security law, technically law number 16 of 2021. We're going to be giving a summary of its main provisions, how it changes the overall position in terms of taking security in Qatar, and also some questions about enforcement and how that will operate in reality. We have as a firm a lot of experience of the implementation of similar laws in both UAE and Abu Dhabi, so we will give some real life examples of the challenges that have been faced in implementing the laws in those jurisdictions. The law itself was published on the 14th of September and comes into effect 1 month from publication, so the middle of October. However, the key thing is that the implementation rules and the establishment of the new security register is yet to happen. The governor of the Central Bank of Qatar has to issue the rules and regulations, and QCSD, the Qatar Central Securities Depository, is in charge of the security register. We reached out to the QCSD this week to ask if there was an update on when the implementation rules will be available, and it seems that it might be some time before they will be published, and so it's unclear when this law will fully take effect so that we can actually proceed to register security. Next slide. So now.
Thank you, Matthew, for the introduction. So before we go into the features of the new law, we thought it would be helpful to give you a bit of background on the existing regime of the security creation in Qatar, and especially in connection with movable assets. The provisions of the civil code and the commercial code, as well as practices and procedures established by government entities, sort of determine the manner in which security is to be created and perfected in Qatar. Generally, there are two types or two categories of movable assets, one being registered movable assets and the other being unregistered movable assets. Registered movable assets are those that the ownership of which are recorded in a register with the government or a government body. These would be, for example, shares in a Qatari company, or vehicles, or aircraft, ships, vessels. So security over these registered movable assets would be considered to be perfected when the records of the ministries or the government entities reflect that a security has been created over those registered movable assets. And this would basically allow third parties an opportunity to investigate and make a search on these registers to ascertain whether or not there is a prior security interest created over those assets. So, for example, a pledge over the shares of a listed company is recorded with the Qatar Central Securities Depository, and a pledge over vehicles is registered at the traffic department, and one could make inquiries at those departments to ensure or to search whether the security exists or not. On the other hand, the unregistered movable assets are those assets whose ownership is not recorded with any government entity or government body. These would include, for example, plant, machinery, equipment, inventory. The law requires, the previous position was that in order to perfect and create the security over those unregistered movable assets, one would have to have a date certain security document, and the most important would be to pass the possession of those movable assets onto the pledgee or an independent third party. Um, for obvious practical issues, it would be very difficult to pass on the possession to the pledgee, because the security provider would no longer have the ability to use those assets. So a practice developed to appoint a bailee, who would ordinarily be an officer of the security provider itself, and that bailee would act on behalf of the pledgee and hold the pledged assets in trust for them, or as an agent on behalf of the pledgee. Now, while this would fulfill the legal requirement, in practice, it would not be possible for any third party to make inquiries, independent inquiries with any government entities or bodies to ascertain whether a prior security interest is created over any of those unregistered movable assets. So, in order to overcome this issue, the movable assets security law refers to or allows for security to be created over certain types of movable assets, debts, and certain rights, which fall under the purview of unregistered movable assets. Next slide, please. So in terms of key developments under the new law, there are a few concepts that have been issued under the new, have been introduced under the new law. The first one would be the introduction of a security register, which is yet to be created. The security interest, once it is registered on the security register, will allow third parties to make independent inquiries to ascertain whether an entity has created security over any of its assets in favor of a bank or a financial institution. The security register would cater to the assets that fall within the purview of this new law, but would exclude or would not relate to any asset for which a security register has been is existing or has been previously created. So, for example, the pledge over shares or pledge over vehicles will not be covered under this security register, because they already have a security register or a security record existing previously. The second important development is the introduction of the concept of a floating charge. The floating charge, so previous position was that that the law allowed security to be created over fixed and identified assets which were existing at the time of the creation of security. In comparison, a floating charge would essentially allow security to be created over assets that are not in existing at the time of security, or by nature the value or the quantity of those assets would change, or both of them would change over the course of time. To discuss an example, under the concept of a fixed charge, it would be a nightmare to create security and perfect that security over inventory of a supermarket, where while you could identify the inventory as at a given date when the security is being created, but that inventory would ordinarily change over the next hour or the next day, and so it would be impossible to create that security or perfect that security over a certain period of time. In comparison, a floating charge would allow the parties to create a security over the inventory of a supermarket on a rolling basis up to a maximum value, and this would mean that in case there is a default, the inventory as at the date of the default would sort of be would freeze, and the bank would be able to enforce its right over those inventory or the inventory as at that date up to the amounts that is owed to them. So this is a key development under the new law. The third key development is that there is no bailee required now. The security provider would essentially act as an agent of the pledgee and would hold the pledge assets in trust on behalf of the pledgee. So there is no longer a requirement to transfer possession of the assets to the pledgee. And lastly, but importantly, the self-help remedy has been introduced into the new law, which will basically allow parties to agree to enforce the security outside of the court process. And this would be of particular interest to the banks because they would no longer have to go through lengthy court process for this. And Roy will discuss this point specifically in the later part of his presentation. Next slide, please. So in terms of what properties or assets can be covered under or can be pledged under the new law, Article 3 of the new law basically identifies a wide variety of assets that can be pledged under this new law, and these include debts payable to security providers, bank accounts, bonds and commercial papers, equipment, tools, devices, tangible, intangible assets, raw material, agricultural crops, movable assets that are not fixed to the land but can later be dismantled in an efficient way as to not destroy the land on which it is assembled, intellectual property rights, trees and minerals before they're being cut or extracted. So this basically covers a lot of assets and a lot of wide variety of assets over which banks are now able to take effective security. Next slide, please. On the other hand, there are certain assets that have been identified that may not be pledged under the new law, and these basically include personal movable assets, which are not, unless the purchase of those movable assets are being financed through a bank or a financial institution. Insurance proceeds that are due to any beneficiary, unless those insurance proceeds relate to a pledged property which is being provided as part of this law. Any employment related wages, salaries, pensions compensated, those cannot be pledged. Public property or property that has any sort of immunity granted to it, any future rights arising out of inheritance or will, joint movable property owned by two or more people, unless the owners of those movable property agree to the grant of pledge, and all of them sort of give their consent to it. And lastly, capital which is paid as purchase price of a project, that cannot be pledged under the new law. I will now let Matthew take over from me and discuss the features of how you can create security under the new law.
Thank you. And a conceptual point which is worth mentioning here as anywhere else is guarantees aren't capable of registration, and that's one of the issues that came out of the UAE and Abu Dhabi, that there were various attempts to try and register guarantees which don't create a security interest and don't fall under the provisions of this law. Next slide, please. So as mentioned at the outset, QCSD is going to be the custodian of the security register, though the rules of implementation are yet to be established. It is supposed to be, or one would hope from the UAE and Abu Dhabi, quite a simple process to register the security with certain information provided, and then the registration will be done online and it should be quite mechanical. QCSD does have, in our experience, can get quite involved in looking at questions of power and authority and other things like that. But we believe, and our expectation is that that won't be the case here. But until the rules are actually announced, we can't be sure about that. It is an electronic register, so submissions will be made online and it will be searchable publicly. And something which is quite a departure for Qatar is the public will have access to the data recorded on the register. The other registers that do exist can be searched in certain manners, but this we're expecting to be far more accessible and so far easier to actually find the information on. The register and the security report, which is what you would print off when you access the register, is proof of the security, registration and priority rights in front of all bodies. So it will be definitive for courts and other purposes as well. A key element here, which we'll come on to later, is that just because you're able to register the security on the register doesn't necessarily mean it is valid and binding. So all of the checks regarding capacity and authority and things like that that we have to undertake prior to execution of security now still have to be done. Registration as such is not a validation of the validity of the security. Next slide, please. So there's a prescribed list of information that has to be provided to enable the security to be registered. The details are here, including the description of the pledged assets. So that can either be specific in terms of describing a particular type of the movable assets of the security provider, or it can be more general in nature by looking to take security over all movable assets of the security provider. There is a slight confusion if you read the law that the security provider can also be referenced as a guarantor because presumably because it can be a third party, so not necessarily the borrower, but just some terminology to be aware of. You have to also describe the rights secured by the security provider, which in a normal situation might be the obligations of a borrower under a facility agreement. As we used to here, the security value, so the maximum amount secured by the pledge has to be stated along with a validity period, which can either be a specific period or until the underlying obligations are satisfied in full. Next slide, please. So again, there's a prescribed list in Article 8 of the new law setting out the requirements to enable the security to be registered. There has to be an underlying security document in writing. Whilst we're not expecting that will have to be submitted to be registered, though we're not sure yet. The point I made about the capacity and authority, that will be for the person who benefits from the security to be comfortable that the person giving the security and the pledgor does actually have the capacity and authority to enter into the document. A key part of the registration mechanism is that the security provider has to agree to both the creation and the registration of the pledge. We would expect that to be included in the security document itself. The default position with regards to the fees involved in the registration, and there's no information yet on what those fees would actually be, is that the pledgee, so the person who benefits from the security, has to pay those. So something else that we would expect to be included in the security document is that the cost of the registration sits with the security provider or the underlying borrower. The general rule of thumb under the new law is that the priority of the pledge rights depends either on the date of creation of the pledge or the date of registration of the pledge. It depends on the specific nature of the security that's being created. So in relation to priority via third parties, then that's typically the date of registration of the pledge, which makes sense because that's the date that third parties will be able to access and see the existence of the security. And aside, any one of you who's had to deal with date certification of assignments and the incredibly difficult and burdensome task that is, hopefully this process will do away with that. Next slide, please. There is also a grandfathering provision, and this reflects the mechanics that was included in the law in Dubai and Abu Dhabi, that you're able to register existing security. There is a 12-month window from the date that the law becomes effective to register pre-existing security. But as we've said, not entirely sure when the new register will actually be working, so that 1-year window might be substantially shorter. If the security was previously perfected, so if it was authenticated, date certified, or whatever was required for the specific security in mind, priority will continue from the date of the perfection of that security. If it was previously unperfected, or because there was no manner in place or no means to actually perfect it or register it anywhere, then priority will continue from the date of registration in the security register. One of the anomalies that this has thrown up in the other jurisdictions is that if we were to, acting for a lender, take security over movable assets next week, or as soon as the new law becomes effective, and we duly register the security on the register, we believe that we have first ranking security over those movable assets. However, another lender might have taken security 2 years ago and only seeks to register that on the register after the new security has been taken. So the pre-existing security would take priority. So this is going to be an issue for the period until, or for the 1-year period until the window that we have to register existing security. Next slide, please. And I'll pass you over now to Roy, who's going to highlight the new provisions around enforcement and self-help.
Thank you, Matthew and Muhammad. So the enforcement is very controversial topic here in this law. I admit it's still not very clear, and everyone, as Matthew said, waiting for the regulation. It should be issued by the Qatar Central Bank, and the law itself that this regulation should be published in the Gazette. We don't know yet when it will be issued, but I'm sure once it's issued, the picture will be more clear at this stage for the enforcement. However, the legislator here in this new law, when it's talk about the enforcement, it creates a new concept, wasn't exist previously, especially from litigation point of view or civil law school in general. Because previously any action, any enforcement, it should be or taking the right of the bank or the pledgee, it should be through the court or at least under the supervision of the court. Here, in this new law, the legislator opened the window for the self-help or agreed enforcement, which is somehow a new concept in the Qatari law. In addition, of course, if it's not working, the agreed enforcement, we can go somehow to the regular enforcement, which is judicial enforcement through the courts with somehow faster track procedures. So for the self-help or agreed enforcement, as I said, it's a new concept. It's simple. Saying that the pledgee just need to send notice to the related parties asking for the position, and then to start the process to sell it by public auction in the price market. There is a few conditions, it's again simple conditions about this agreed enforcement. It's simply, it needs the both party, for example, bank and the client, the customer, should be agree this in writing, that both party can go in this agreed enforcement or self-help. That will lead us, of course, Matthew will talk about this, that some standard documents should be amended to reflect this condition, especially for the banks. And of course, if there is other pledgees, then the notice should be sending to them as well before sell these assets in public auction in the agreed enforcement. Article 28, it gives good news for, especially for the banks, talking about also to the agreed enforcement regarding the credit accounts. We received on regular basis, sometimes on daily basis, question from many banks about, can I do this set off? What should I do? Should I send a notice or not? So here, Article 28, it gives the banks the right to do set off regarding the credit accounts and also some documents, and even not only to cover the right itself and also the expenses. It's not clear yet what expenses mean, like to include only the banks, the legal cost, I don't know, but it's give space for the bank and legal ground for the banks to do some set off with a more solid ground. And with the simple conditions, and even one of the conditions or the thing that the bank and the clients can agree on, that the pledgor can waive in advance his right to get the notice also from the bank. But if this condition will apply, it should be amend the standard documents again, as Matthew will talk about this specific point. The other way, because the legislator here talking in Article 29, saying that if the agreed enforcement cannot take effect or it's not working, then you have to go to the judicial enforcement with somehow fast track procedures. We can go to the next slide to explain it quickly. Joanna, can we go to the next slide? Okay, so in the enforcement court procedures, it's in theory it's simple, it's fast. Practically, we know that there is some challenges in the enforcement court. So in theory, the pledgee submit an application to the enforcement judge, and then the enforcement judge within 3 days should notify all the related parties, send them notification, and then once the pledgor receive this notification, they have 5 days to settle, to pay, to settle the matter in a smooth way, or in the same 5 days, they should file an objection about this application to take the position. The application is the pledgee asking the court to take the position of the assets. So they can make an objection within 5 days. And then after 5 days of the objection, the enforcement judge should take a decision to take the position of the assets and thereafter to sell it in an auction or to accept this objection. This decision issued by the enforcement judge, it can be appealed before the competent court within 5 days. So we can see here how much is fast track procedures. On the ground, I'm not sure how it will be working smoothly, but hopefully we are always optimistic about this. So within 5 days, the appeal should be filed with the competent court, and then the competent court should issue its judgment. The final judgment cannot be appealed again within 10 days. So within 10 days, it should be take the final judgment about take the position and then to sell it in the auction or to accept the objection. And if the court stated that the process are correct, the application is correct, then the auction procedures will start there. It's somehow a little bit detailed, so we can talk about it maybe later on, especially when we get some experience with this. And then it leads to sell the assets in the public auction, and then this money will go to the escrow account in the court, take the priority for the pledgees, and depends on the priority, of course. And if there is remaining amount, then the pledgor can take this money back. So this is in general the judicial enforcement, and as we discussed before, the agreed enforcement is very new concept here. It will be a little bit challenged, but of course the key point is to amend the standard documents here to reflect this new law and to be able to use this new concept. And one interesting thing in this new law is about the penalties. It's clear the party who make issues or try to destroy the assets or make obstacles in the enforcement. There is harsh penalties here. There is fine up to 1 million or imprisonment, jail up to 1 year. So there is fine and imprisonment here. So the legislator is serious about not allowed any parties to make issues here with the enforcement process. I'm sure that once the law is legally and practically implement and have some experience and cases, then we can have more webinars about this controversial topics, actually, enforcement. And of course, we'll use our experience in the region to implement this new law and the new concept. So now we can go to next slide, and maybe Matthew can continue.
I think just picking up on the point there, one would hope that the right of set-off, if it's contractually agreed, is less likely to be challenged than the other ones. And of course, if the bank exercises its right of set-off, then it reverses the burden it's for the other party to try and challenge that it wasn't entitled to do that. And as Roy said, there are cases trickling through in the other jurisdictions now. And so one hopes that frivolous challenges just to try and prevent enforcement will be cast out quite quickly by the courts. Although another point that has just been made by one of the audience is that the courts are already under substantial pressure dealing with existing caseload.
It's a good question, actually. First, I agree with Matthew about the set-off. It's more smooth without the problem because the legislator give it a separate article, which is Article 2028. So it's covered this set-off, especially for the banks. About the question about the pressure on the enforcement courts, I totally agree that there is ongoing pressure now, and especially banks are a little bit suffering because they have many enforcement cases, and the load is huge. But my personal opinion is that once this law is in effect, then the enforcement court, I think they will create a special court or room to handle this kind of cases. So for that reason, I think it will be properly handled by the courts.
Thank you. Very briefly, before we come on to Q&As, some practical issues which expect to come up. The time delays in terms of setting up the register and the regulations, the backlog when thousands or tens of thousands of security documents from years back are registered. And then some issues around, for example, capacity and authority checks. There's very specific rules about what information needs to be provided in order to register security, which is fine for security documents going forward. We can make sure that all of those are provided. But for security that was signed 2, 5, 7 years ago, what the approach to QCSD to that will actually be.
And it's building on to that, there are some other practical issues in terms of the processes at the Ministry of Justice. Those would still continue, and we would expect that the registrar, the QCSD, would sort of require the documentation to be properly authenticated at the Ministry of Justice before the security is recorded on the register. the security ranking issue that Matthew discussed earlier, that there could be a potential issue of security ranking for an existing unperfected security interest, and a subsequent bank could sort of end up getting priority before a prior bank if it manages to register its security on the register before the other bank. And obviously, it will be very important to have an efficient system in place from the QCSD, because there are the perfection steps would be time sensitive, and you would want that the time period for actually registering the security is as short as possible, and then not sort of going up to days or weeks. And finally, Roy discussed some of the challenges in self-help scenario, which could be that while there is self-help permitted under the law, you could always end up in a scenario where there's a challenge on the bank's ability to enforce their security, even though the self-help is agreed in the agreement. We're sure that some of these points will be cleared out in the implementation rules, but like we discussed earlier, it's not clear when those implementation rules would be in place. So one needs to sort of wait and watch on this. Next slide, please. And so what is the current status of the law, and what are the next steps that banks and companies should take? Like we said, we're still waiting for the law to come into force sometime next month, and for the implementation rules. And like Matthew initially discussed, we are constantly monitoring the progress on this point, and right now there's a bit of uncertainty as to when the register would be set up in order for banks to sort of start doing this registration process.
But in the meantime, until the regulations are a little bit clearer, banks can start reviewing existing security templates with a view to perhaps agreeing amendments to some of them. So, for example, the point that Roy made about agreeing to the self-help remedy, and also perhaps a further assurance clause compelling a borrower to provide all cooperation to allow security to be registered when that is actually possible. But there might
and also the waiver of the right of notice.
Yes.
As well.
There's also some considerations in terms of some of the products that are available in the security package and the credit analysis. If it's now possible to get registrable security over particular assets that previously it was either very difficult or impossible to get priority over, and that can change the risk profile of borrowers. And the other point which I touched on earlier is being aware of other interests that actually have priority, both in terms of pre-existing security or security over other assets. That's the end. Next slide, Joanna. That's the end of the formal presentation. We'd be happy to accept or to take any questions that you have. We have a few already, so just viewing them here. One of them, a administrative one about slides. We'll circulate the slides afterwards, and this webinar is actually will be uploaded onto our website. Should you want to see that. A question to Roy about whether assignments will be covered under the law.
Assignment, it's mentioned in Article 4 in the law, if I'm not wrong, and the question is related to the previous, or the assignment has been signed signed before issuing the new law. I think Muhammad talked about that there is 1 year period to register the previous securities, and this will be linked to the date of issuing or make the register working actually, which is it's not clear yet. But the 12 months, it's a start from the effective date of the register, correct?
No, it's 12 months from the issuance of, from the effective date of the law, and that's where the issue comes up, where there would be a time lag between when the register is actually set up. It could be 2 months from now or 6 months from now, we don't know. And that sort of eats into the time that is given in the law to register your previous security.
So if the register get effect after maybe 10 months, then we have only 2 months to register the previous one. So,
yeah.
So a couple of other interesting questions. One, will it apply to all companies within Qatar, so free zones as well as normal ministry companies?
Free zones have their own security regulations. So, for example, Qatar Financial Center has its own securities regulations, and so does the Qatar Free Zone Authority. So this would typically apply to Qatar onshore regime, because there are other security laws and regulations that are applicable to those jurisdictions.
Thank you. Another question was about will the register have a way to see the progression of claims as security interests, because there might be limits on the information that's publicly available. How we envisage and see this working will be that once a security interest is registered, then that becomes definitive. As we say, that there is no there shouldn't be any checks for QCSD on the actual validity of the security as such, but if all of the relevant information has been provided, then that will be registered. There is a mechanism to dispute the register from the security provider, so correct errors and things like that can be corrected. But once the security appears on the register, we expect that to be definitive. One of the, I'll get the next one and then pass to Roy about if you're pledging current accounts, how do we identify the pledge amount? Do you have to sign an addendum every 3 or 6 months? So that is reflecting the mechanics of taking an account pledge now, where you can only take security over an identified amount, which you then take an addendum to update the amount that you're securing. But the characteristic of a floating charge concept with this, which is introduced by the new law, is that you don't have to update it. You have security of the fluctuating amount in the account, and then you effectively have security that you can enforce whatever amount is standing in credit to that account on the day of enforcement, which typically with a bank account would be unset off. So you can put, if you wanted to or you needed to, place certain restrictions around amounts that have to be in the account and withdrawals and things like that. But the fundamental point of this is that it will be a fluctuating amount changing from day to day, and then you will have the rights over whatever is on the balance on the day that you choose to enforce the security. Yeah. If you want to take this one about vehicles currently pledged.
Machines or vehicles currently pledged with the traffic department, but the new law affects the interest registered by other parties. But so the question is what effect would have on the vehicle pledges, which are
vehicles, yes.
Yeah. So vehicle pledges, we would expect that it would not fall within the purview of this law. The vehicles are not specifically mentioned in Article 4 of this law, which sets out what are the assets that could be pledged. This is primarily because there is a separate register or a mechanism introduced with the traffic department, where you would register your security interest over vehicles. So vehicles they would continue as it is, and the mechanism for the creation and perfection of vehicle pledge would continue outside the scope of this new law.
Yes, Ismail, here it's not about only the vehicles, because you know that the price may go down, so you can take other pledge over the assets from your client, like machines or motors, because There is no specific registration like the vehicles. So I will call you after the presentation to explain what exactly you can take security from your client, and it should be registered here as per the new law.
A question here from someone regarding to which assets this applies. Probably no way related to the fact we're doing a transaction where we're taking security outside of Qatar. It will just be relevant, as I understand it, to assets located in Qatar. There's nothing to suggest that there's any extraterritorial impacts. It will just be assets which are located in Qatar. Do you want to answer how will ranking be determined?
Yeah, so there are various provisions under the law which talk about ranking. Generally, ranking would determine from the date of registration in the security register, if it's a new security. If we're talking about a previous security which was perfected under the previous regime, you could register your perfected security in the security register, and there is clear provision in the law which says that if there is a previous perfected security, your ranking will not be affected. It would continue from the date of the original priority or the original date of the security being perfected. I hope that answers the question.
There is one question about when or the time frame to get this law in place. As Muhammad said, it's issued mid of September or like 14 September without mentioning the specific date. And the Constitution of Qatar, it says that if there is no specific date, it will be after 1 month of publishing in the Gazette, which is 14 September. So in theory, it should be like mid of October. But of course, practically, there is a regulation, there is a register to be created. There is a lot of challenges. But like from purely legal point of view, I would say mid of October.
And another question here is coming from a lender. Can another lender take a pledge over a customer's bank account with another bank and an availed loan with us without the consent? Now, if there are credit balances standing to that account, then that is an asset of the customer. So on the face of it, they could grant security over it. There would be issues around enforcement and in terms of how any beneficiary of that security would seek to enforce that security. I don't know, Mohammed, if there's any thoughts, but on the face of it, there's no reason why.
Yeah, I think there is a specific provision under the law which talks about the pledge over deposit accounts. And I think it is possible to create a pledge where a customer has a bank account with a particular bank, but they could create a pledge in favor of another bank. We could specifically check what are the perfection requirements, what are the control requirements, how you would ensure that the priority is there. We could specifically address this after this webinar. Yeah.
Another question is, does a charge apply on the shares of a mainland company or only on the assets? So our interpretation of that would be that as it is possible already to take share security and register it, so you register the existence of the security over the CR, then this law wouldn't apply to the shares, share security, just to the assets. Let's see if there's... Yeah, so picking up on a couple of points, there's obviously a number of people representing banks here regarding this point about taking security over bank accounts, about whether a bank that holds an account that the customer is looking to grant security over in favour of another bank, whether a no objection certificate will be required. Again, we can look at this in more detail because there's nothing specific about that in the law as it is at the moment. On the face of it, because there isn't a requirement for a no objection, then that shouldn't be required. And the questions, I suppose, for Roy is in terms of how that would sit with contractual rights of set-off that the account bank has.
Yeah, the principle exists under the Article 28. We can send you after the presentation the 28 what it stated about this specific point, and but we have to remember the condition of Article 28, that it says that both parties should agree on this, especially if the bank can do the set-off, if there should be notification or not, if there is waive of the right of the notification or not. So all this condition, it should be there and discussed. And for that reason, we highlight that some documents should be amended before doing this.
Okay. Can the shares of an unlisted company be pledged under this law? I think the same analysis would apply in terms of even with an unlisted company, it is possible to register the existence of a mortgage on the CR via the MOCI. So because there is an existing registration mechanic, then the law wouldn't apply, our interpretation. Okay. I think that's what I've covered them all. Yeah. Okay, I think in the absence of any other questions, then I think we've now been through most of the questions that have been raised. As we say, if anyone has any further questions or we've not addressed them properly, we'll review the questions and reach out to you. Our contact details are here, and we'll be more than happy to speak to any of you about the provisions of the law. We'll circulate a further client alert when the regulations are known, and we've had a bit of time to analyse them, so we can give some more practical advice on what you should be doing to address this. As I say, we'll circulate the slides as well, and the presentation will be available on our website. Should you wish to share this with family and friends, and your Netflix subscription has expired. Thank you all for joining, and we look forward to speaking to you all in the near future, and we will update you again when the new regulations are published. Thank you. Goodbye.
Thank you.